It's if you may impose. So if your statute says that it's punishable by 2 years in jail, it doesn't matter whether the person actually gets any jail time or not. These protections are still required.
Thanks, Steve. Some of the other requirements are to have the tribe's rules of evidence, their code, rules of criminal procedure made available to the public prior to charging the defendant. The tribe needs to record the criminal proceeding, whether it's audio or some other type of recording. And you see here, there's some of the check marks are TLOA and VAWA, TLOA only, or VAWA. The ones required by VAWA would be providing the defendant the right to trial by an impartial jury, as well as ensuring that there's a fair cross-section of the community within the jury pool, and that juries are drawn from sources that do not systematically exclude any distinctive group within the community, including non-Indians. The other requirements under VAWA would be that anyone detained under the special domestic violence criminal jurisdiction is timely notified of his or her rights and responsibilities, that they have and are notified of the right to petition a habeas corpus from the Court of the United States, and that all other rights whose protection is necessary under the Constitution of the United States in order for Congress to recognize and affirm the inherent power of the participating tribe to exercise special domestic violence over the defendant are provided, and that all the rights under the special domestic violence criminal jurisdiction provisions are provided. And with that, I would like to turn it over to Kelly King-Stoner to discuss domestic violence court and docket.
Thank you for that overview, Chia. And as we move into this section, what I hope to do is to focus on the difference and the purposes of a domestic violence court versus a domestic violence docket. And I think the whole team here of presenters is really wanting the audience to take away, to give you some ideas, some tips, some things to think about as you go back and review certain OVW grants to match, as you select these items you'd like to implement in your court, you can sort of match those to some sort of purpose area or grant. Okay, when we talk about domestic violence courts, we're really talking about a specialized court. It's a court that would have everyone in it, let's say, is on the same page. They're all trained in the dynamics of domestic violence, the fact that in these cases you have to keep safety at the forefront, representation. Chia, can you move that slide forward, please? Okay, there we go. And again, it's an entire court. It's going to handle all kinds of cases that have that common thread of domestic violence running through it, whether it's a civil case or a criminal case. And anyone who's worked on these cases know that there's a lot of overlap between the civil and criminal system, that cases are highly litigious. Sometimes the batterer seeks to use the systems against the victim. So this domestic violence court is, again, going to be specialized. Everyone in it is going to be well-versed and educated in all of these dynamics. Again, thinking about safety always being at the forefront of the representation or even the proceedings going through the court. It also will allow a tribal court to incorporate unique tribal customs and traditions that the tribe prioritizes with respect to healthy families. We all know that batterers oftentimes come back, that families oftentimes go back together or try to go back together, and so this allows some latitude for tribes to implement into the court process and possibly the service process those types of approaches that the tribe thinks promotes healing in a healthy family, again, as long as the victim is safe. I think also this type of court builds a stronger relationship among service providers. It sort of, I would envision a domestic violence court what might have a specialized investigator, a specialized prosecutor, a specialized advocate, a specialized social worker, all of those folks, again, working together towards family health. Yeah, thank you. Domestic violence courts, I think, are incredibly important. They're incredibly important to the health of families. And let's start with the victim. We all know that the court systems, most court systems as they stand, are not victim-friendly. They're not victim-centered. Think about child protection oftentimes removes children from the home when there's any allegations of domestic violence, further traumatizing the family, traumatizing the victim. So these kinds of courts are going to be already familiar with that. They're going to be on the same page with protocols. They're going to safety protocols, keeping victims informed about what's going on in the case, keeping safe. The advocate will be keeping the safety plans up to date. And I think also with this team approach, this holistic circular approach, it really empowers everyone on the team as well as the victim to try and address the issues of safety as well as batterer accountability. I think also oftentimes pushed to the back is the issue of court safety. Anybody who's been in this work for very long, anybody I know is sitting on the bench, I'm keenly aware. These cases come highly charged with a lot of emotion. And so we don't want the courtroom to be a place that we forget about safety. The domestic violence court would have a safety plan. There would be some safety mechanisms in place, particularly when entering and leaving the courtroom. Oftentimes, tribal courts may, everyone parks in the same parking lot, and the victim and the batterer are going to have to go in the court through the same door. This would get everyone on the page of safety, and maybe alter some of those protocols to provide more enhanced victim safety with respect to courtroom entering and exiting, and also as the case plays out in the court. Also having law enforcement that understand how volatile these cases are. And I mentioned earlier, not only focusing on victim safety, which is really, really just the key to having any hope of the victim being healthy and moving on, is to hold the batterers accountable. Sort of a message from society, whatever tribal community might choose to implement this type of court, that our community does not accept this. And so these courts, as I mentioned earlier, would have specially trained judges and law enforcement. There's the issue of cross-pollination of batterer records with the team approach, that if, let's say, the batterer doesn't attend the batterer intervention program, has too many absences or something of that nature, that would be relayed to the probation officer and those sorts of things. We've already talked about incorporating culture into this, not only from the victim safety, family healthy piece of it, but also batterer accountability. What does the tribe really feel that batterer needs to do to get healthy, and how's that community going to hold the batterer accountable? And also, I think domestic violence courts can really take their time. It's not a numbers game, hopefully. It is a time of monitoring and supporting and tracking. And so there should be built-in review hearings where you can actually see the progress or lack thereof. Domestic violence courts also promote this team approach, this coordinated community response. We've already talked about this. Agencies will come together, hopefully work together, provide opportunities to get to know one another. And I think this is a really important piece to the domestic violence court. I think It takes some effort. It takes some doing. Get it, because judges see through a different lens, let's say, than the prosecutor or the social worker or even the advocate. And so folks getting on the same page with some common goals and kind of cranking through this to come up with some protocols. Okay, so that's what we would hope a domestic violence court might look like, or at least contain some of those components. Let's think about funding barriers, and we'll kind of wind up at the end, hopefully, with Judge Aycock sort of bringing us back to some possible ways to address these funding barriers. Oftentimes, if a court, and we saw that slide she had put up at the beginning about those federally recognized tribes that are already implementing the VAWA 2013 Section 904 Special Domestic Violence Criminal Jurisdiction over non-Indians. So in order to do that, tribes most generally are going to have to review their tribal constitutions and codes and make certain revisions to those. That's because those codes oftentimes were written thinking that there was no jurisdiction over non-Indians, or thinking using the boilerplate BIA constitutions. They'll have to do policy and procedure reviews. How do you pull that jury trial? Does the tribal code of the tribal court that's doing this, does it allow for the juries to have non-Indians on it? Because one of the things that VAWA 2013 Section 904 is going to require is that you cannot systematically exclude any group of individuals that comprise this tribal community. Often there'll have to be funding for specialized judges. Not all judges are trained in the dynamics of domestic violence, so certainly if you're thinking about a domestic violence court, you're going to be wanting a judge that is. The court personnel will have to be trained, law enforcement, the court administration, everyone has to be on the same page with respect to the dynamics of domestic violence, the tactics the batterers might be using, and the issue of victim safety. You have to think about where you're going to incarcerate anyone that's convicted in the domestic violence court, and perhaps that's going to be a non-Indian. Where are they going to be incarcerated? Who's going to supervise the probation? Who's going to pay for the health care that might be needed during the period of incarceration? And you also may need to get technical assistance and training to help you get this all in perspective and to reach and maintain your goals. So from that unit, now I want to move into if you're not ready as a tribe for a specialized domestic violence court, then probably the next best thing would be a specialized domestic violence docket. And again, I would hope that your judges are trained in domestic violence. I think that's totally key. But in a domestic violence docket, this would be held like any other docket, only your domestic violence cases would be held on a specific day and time. They might be civil or criminal. And what this does is provide a measure of continuity for the victims. Hopefully they're going to be coming in front of the same judge. The judge will be somewhat familiar with the case. On these docket days, there need to be special safety protocols put in place. A lot of the same things for the domestic violence court, but you're only going to be doing these on the days that the domestic violence docket cases are being heard in your tribal court. And you can kind of read down through that slide. Again, does a lot of the same thing the court does, but it's just a sliver of a domestic violence court. It's just sort of a special docket day or days. Possible barriers to the domestic violence docket. It may not provide the continuity of domestic violence court. It just may not. Judges may rotate in and out. And it's not going to have the same team approach to it that a domestic violence court will have. It may not provide a platform for exercising special domestic violence criminal jurisdiction. It may require funding again for tribal constitution or code revisions, reviews. May require funding for additional judges. POs happen, protection orders happen 24/7, so you're going to have judges on call, both for this and the domestic violence court. And again, as judges change and rotate, there'll have to be ongoing training for all court personnel, and the advocate is oftentimes, or a tribal coalition is oftentimes the best place to get that training on the dynamics of domestic violence and the safety issues that are involved in these cases. So the next two slides, I'm not going to necessarily go over those, but what they are resources, and you'll note on the slide it's lit up in blue. Those are, I think, live links. You can click on to those and it'll take you to that exact article or document. We wanted to provide you with a lot of resources as tribes are exploring and beginning to implement this section 904 and possibly a domestic violence court or docket. The next slide also contains some additional resources here. And one of the things we wanted to include, and I think it's incredibly helpful, are the very first tribes that began to exercise this special domestic violence criminal jurisdiction in domestic violence cases over non-Indians committed in Indian country. A lot of their forms are located on these links here. Some of their articles, their concerns, what they think work well, doesn't work well. It's just rich in resources here. If you're interested in just looking to see what could we do, what do we want to do, let's prioritize it, and so on and so forth. So I think with that, we're ready to turn it over to Judge Aycock to talk about how to fund these courts and dockets.
I think first we are going to turn it over to our OVW representative, Teresa, to discuss CTAS and the Purpose Area 5.
Yes, thank you.
Forgive me if there's mistakes, and I know Teresa will go ahead and correct those. Thank you.
No problem. Good afternoon, everyone. Yes, I will be speaking about CTAS, the Coordinated Tribal Assistance Solicitation, which provides federally recognized tribes and tribal consortia an opportunity to develop a comprehensive and coordinated approach to public safety and victimization issues and to apply for funding. Under CTAS, there are 9 purpose areas that's monitored and managed by OJP, the Office of Justice Programs, COPS, and the Office on Violence Against Women. Currently, the CTAS solicitation is opened. It opened November the 19th, 2015, and it will close on February the 23rd. Again, February the 23rd, 2016, and applications must be received by February the 23rd, no later than 9 p.m. Eastern Standard Time. Next slide, please. As you can see, in 2005, we received 84 applications under CTAS, and of that 84, we awarded grants to 52 tribes. Currently, we have an estimated amount of funding of $32 million, and that was the same amount last year. The programs under Purpose Area 5 is 3 years. The project duration under Purpose Area 5, which is the Tribal Governments Program, is for 3 years. And you have 2 OVW point of contacts. As you can see, Lorraine Edmo, who's our Deputy Director of Tribal Affairs, and myself, Teresa Payton, and I'm a Program Specialist in the Tribal Affairs Division. Next slide, please. Next slide, please.
Sorry, there's a lag here. I'm not sure if it's showing up yet.
Okay, no problem. Thank you. For Purpose Area 5, also referred to as the Tribal Governments Program, there are 9 statutory purpose areas under the Tribal Governments Program. Another word to use for statutory purpose areas is the goals and the objectives under the Tribal Governments Program. And of interest to this call, there are 4 purpose areas or goals and objectives that's related to courts and dockets. And I'll just highlight them. And I would like to also note that the information that will be highlighted is in CTAS under pages 24 through 30. And you can read all about the CTAS programs, all of the requirements, and all of the detailed information that you will need to know when you apply for a grant under Purpose Area 5, which is the Tribal Governments Program. I will highlight that there is a collaborative partnership requirement. You must partner with a victim services organization, a tribal coalition, or you can have a women's advisory committee. And there's details regarding what that collaborative partnership must include. And again, you will be provided more information about that collaborative partnership when you apply for a grant under Purpose Area 5, and you can also reach out to your point of contact, Lorraine, Edma, or myself. Now, I will talk briefly about the 4 purpose areas under the Tribal Governments Program that's related to courts and dockets. And again, this information is under pages 24 through 30 in CTAS. One of the goals and the objectives that's related to the courts and dockets is to develop and enhance effective plans for the tribal government to reduce crimes against Indian women and increase the safety for Native women. Some examples of what you can do under that particular goal and objective is revise tribal codes, investigation and prosecution of crimes, and also establishing a court-ordered and court-monitored BIP. Another activity is to increase the ability of the tribal government to respond to crimes committed against Indian women. For an example, training Indian country professionals responsible for investigation and prosecuting, or training healthcare professionals and hiring law enforcement staff. That's some of the things that you can do under that particular purpose area. Also, to strengthen the tribal criminal justice system's ability to respond to violence against Indian women, some activities that you can do under that purpose area is hiring judges, court staff, probation officers, and other staff at tribal jails to enhance their ability to respond to crimes of violence against Indian women in Indian country. And the last one is to provide legal advice and representation to victims of crimes who need assistance with legal issues that are caused by the abuse they have suffered. For an example, legal representation or advice in family law cases or civil cases directly related to the abuse they have suffered. One thing you have here noted to see RFP for a list of discouraged activities, or what I will refer to as unallowable activities and victim safety issues. Some of the general unallowable federal activities are fundraising and renovation, just to name a few. But there are a number of victim safety issues that we want to make sure that we have in place. For an example, offering criminal defendants who have been charged with crimes related to domestic violence, dating violence, sexual assault, or stalking to avoid prosecution by agreeing to participate in another type of program, such as a drug court or some type of diversion program, or agreeing not to commit another crime for a specific period of time. These are things that we look for, that we consider activities that may compromise victim safety. Also, ordering victims and offenders to attend mandatory couples counseling or mediation. Operating a domestic violence battery intervention program that is not court ordered or court monitored. Operating an anger management class instead of a battery intervention program. Using practices or procedures that fail to protect the confidentiality of victims. And last, referring victims to child protection services solely for failure to protect their minor child from witnessing domestic violence. And also, if you decide to select the activity for legal representation, we also require a legal certification, which is a letter to say that you understand what the requirements are if you actually are delivering that activity. Next slide, please. Again, my name is Teresa Payton, and I work in the Office on Violence Against Women. I'm one of the program specialists in the Tribal Affairs Division, and you can always reach out to myself or Lorraine Edmo, my Deputy Director, who's currently out of the office. But if you have any questions, you can always reach us at OVW. Thank you very much.
Thank you, Teresa. I will be sure to make some corrections on the slides with the due date, and I'll send it out to the participants. And if it's okay, I'll include your contact information as well.
Yes, thank you very much.
Thank you. And then if we'll see if there's any questions at the end specifically for you. Thank you. And with that, I'll turn it over to Steve Aycock.
Thank you, Chia. My name is Steve Aycock. I'm the judge in residence at the National Council of Juvenile and Family Court Judges. And I want to talk to you about a couple of other OVW-funded grant programs. These two that I'm going to talk about, the Justice for Families program and the Rural Sexual Assault, Domestic Violence, Dating Violence, and Stalking programs, these are not targeted just for tribes. They're open nationally, but tribes and tribal organizations can apply for grants under these two as well. So you're not limited to just applying under CTAS. These grants also, I'm not going to go into them, but these grants also have many of the same, if not the same, unallowable activities as Ms. Payton just talked about under the CTAS. Next slide. So the Justice for Families program, and it's trying to improve the response of the civil and criminal justice system. And there are actually 8 purpose areas, but this year only these 5 are being funded. And in my discussion, I'm going to focus on Purpose Area 3 and Purpose Area 5, since we're talking about court and court-based information. So the grants have purpose areas and tell you what it is that you can apply for, but it also then, they have a section just called priority areas. So what is it that they're sort of in a broader sense looking for rather than just what is it that your program is going to do? And under the Justice for Families, it's meaningfully increase access to OVW programming, increase the use of promising or evidence-building practices where available. In those, if you're going to try to emphasize these priority areas, they want you to show this authentic commitment to addressing those priority areas. And both the grants say that you may, if you highlight these priority areas, you may be given special consideration during the review process. This solicitation for the Justice for Families opened on the 24th of November. It closes January 21st. I know that's coming up relatively quickly. You have to register for GMS. They expect no later than September 30th, the grant award would be out. As I indicated, it's national in scope. It's new applicants only, except current and former safe havens and court grantees are considered new applicants. But if you are a court or safe havens and your funding goes past September 30th of this year, then you have to apply in a purpose area different than what your current grant covers. If you got funding last year for the 24 months, then you're not eligible. And this tells you who all is eligible. So you can see that courts and Indian tribal governments are covered, as well as a lot of these stakeholders. One of the things when I was looking at the grants was trying to figure out what does court-based and court-related personnel include. And as you can see, Purpose Area 3 is really about training individuals. So OVW has defined court-based and court-related personnel means persons working in the court, whether paid or volunteer, which include clerks, special masters, domestic relations officers, administrators, mediators, custody evaluators, guardians ad litem, lawyers, negotiators, probation, parole, interpreters, victim assistants, victim advocates, administrative personnel, or other professionals or personnel involved in the legal process. It also includes court security personnel, people working in related supplementary offices or programs such as Child Support Enforcement Office, and any other court-based or community-based personnel having responsibility to address domestic violence, dating violence, sexual assault, or stalking in the court system. So it's very, very broad. And these last 5 points are the kinds of training that you can do. So you can do dynamics of domestic violence or perpetrator behavior, the needs of victims. If you apply under Purpose Area 3, you also have to propose a project under either Purpose Area 1, which was the safe havens, or under 5, which is the courts. And this is Purpose Area 5, the courts or programs. So it enables courts and court-based and court-related programs, and it's to develop or enhance these areas. So infrastructure, here's a specialized docket. It could also be a specialized court. Community-based initiatives, so Court Watch, where you actually have people from the community that come in and sit in on court hearings and take some notes about what's going on in an attempt to sort of keep the courts accountable. Information storage, sharing, community outreach, and I think an important one is this offender management, monitoring, and accountability program. You can apply just for Purpose Area 5, or you can apply for 5 plus some of the others if you want. There are some partnerships required if you apply for the Justice for Families. So if the lead partner is your court, you have to have a victim services provider. If the lead partner is a victim services provider, you have to have the court as a partner. And if the lead partner is neither a court nor a service provider, then you have to have both a victim service provider and a court as partners. So these are really important that you understand that you can't just be going in by yourself and making these applications. Now, if you're a tribal government, it's probably a whole lot easier to comply with requiring those partnerships. Here's the money. So both purpose areas, the maximum award amounts are $600,000, and both of them are for 3 years. And they both will require you, when you're doing your budget, to have a full 3-year budget. And now I want to turn to the Rural Sexual Assault, DV, Dating Violence, and Stalking Program. And again, the purpose of the program itself, on the next slide, please. This is the purpose of the program generally. So this is what it is that they want to do. And I want to point out the third one, collaboration is encouraged. And the whole idea here is that if your court, law enforcement, prosecutor, service provider, if you're all just sort of doing your own jobs, but you're all in silos about the DV program, that's not very effective in terms of either victim safety or batter accountability. And that's what Judge Stoner was talking about earlier. And so collaboration is encouraged under this grant. Here are the purpose areas. Next slide. So here are the purpose areas for this grant. You see the first one, encourage collaboration among stakeholders. But it's also expanding nonprofit, non-governmental victim services, and then just increasing safety. This grant also then has some priority areas. Again, those look a lot like what we looked at before, so increase services, meaningfully increase access. And then this third one, establish or increase support for rural and tribal domestic violence dockets or courts. And again, if you talk about these priority areas, you may be given special consideration. So this solicitation opened December 8th and closes February 1st. You have to be registered for these different programs. They strongly recommend a letter of registration. And again, they're hopeful to have the awards out by September of 2016. So who's eligible for this rural grant program? And if you're in a rural state, and they list what those states are in the solicitation itself, or if you're a rural area or community, and a federally recognized tribe is a rural area and community as defined under the program. So you're going to be eligible for this program. Again, this one requires partnerships. You have to have a victim service provider either as the lead or a project partner. You have to have at least one partner, even if you're the victim service provider. You still have to have a partner. And you need to have an MOU, except if you're going to use the court, then the court, you can do letters of support rather than an MOU, because some courts will not sign an MOU thinking that it's an ethical violation showing some bias, but letters of support are okay. And then here's, again, the funding for this. So the continuation awards are $750,000 max, so if you've got a previous award. If you're a new applicant, it's $500,000. Sorry about missing that zero there. And they think there'll be about 50 awards for $33 million total. And again, these awards are for 3 years. I want to turn now to a little bit about just some ideas and some things I've learned in writing grants and applying for grants. So the first thing is to read the grant solicitation carefully and fully. You've got to read it probably several times from front to back. There are lots of requirements that are listed in the solicitations, and they're not necessarily linear, so you can't just go someplace and say, oh, here's all the requirements. They are spread out throughout the solicitation, and it's really, really important that you read it carefully. I have put the links to the 2 grant solicitations that I've been talking about, the Justice for Families and the Rural. And they encourage you, if you have questions, ask. So there's OVW's number for both of those grants to call. And if you don't want to call them, call one of us. Get a hold of one of us, the TA providers. We may have some limited ability to help you, but we can answer questions. So you see the first thing, reread the solicitation. It's so important. Create and follow a solicitation requirement chart. And that's what we've included as handout 1, is a chart, and it's very detailed and very long, and it's not applicable to the grants that we're talking about, but it shows you what we've done here at the National Council. So in 2013, we were applying for a technical assistance program grant, and this is the form that we used to make sure that we were making meeting all of the requirements of the grant solicitation. So I would encourage you to do that. Again, follow all the requirements and all the timelines, and think about what the points and what that means for length. And I've given you some examples here. And just so that you know, the rural, for example, is 20 pages and 60 points. So that's 3 per page. So just think about how that's going to work. And I'm going to turn this back over to Chia.
Thank you, Steve. Now we have some time for questions. If there are any, feel free to type it in here or raise your hand. I can try to unmute you if we get a hand raised. If not, you can always, let's see,
Yeah, this is Kelly while you're looking at that. I just want to tack on to what Judge Aycock said with respect to how you're drafting your grant. If you will put it in the order of the RFP, Follow that very carefully so that the peer reviewer doesn't have to say, you know, the peer reviewer is looking at the RFP and having to search all around for different pieces. Your narrative needs to be in one spot, and it has certain components to it. And your timeline needs to be in a certain spot. So be very aware of that as you look at the RFP too, and have your grant mirror the order the RFP is setting out.
Thanks, Kelly. I don't see any questions right now. If anyone happens to think of anything after the webinar, feel free to email me. My email is chia@tlpi.org, and I will email this PowerPoint out with the corrections made to those of you who have attended, and I will include Teresa's contact information if you have any questions specifically about CTAS for either her or Lorraine Edmo. And I still don't see any questions. And then again, there's the handout, so be sure to download that. I can email it out along with the PowerPoint in case you're not able to download that right now. And Steve, Teresa, or Kelly, any last comments?
No.
No, did you talk about joining ITWIG?
Oh, thank you, Steve. I forgot about that. So if any of you if your tribe is thinking about implementing special domestic violence criminal jurisdiction under the VAWA 2013, please join the InterTribal working group. And you could email me about it, or if you look on NCAI has a page specifically about the special domestic violence criminal jurisdiction. If you just type in on Google like NCAI VAWA, it'll direct you to that homepage, and there's a wealth of information about the special domestic violence criminal jurisdiction and some links to joining the InterTribal working group. So it's a group of tribes that have been meeting for, I guess, the past 3 years now. And it's probably about 50 tribes or so. It's a voluntary group, and it includes those tribes that have been exercising under the pilot project and who are exercising now. And it's a great resource. Everybody comes to meet together. We've had, I think, 4 or 5 in-person meetings. There will be another in-person meeting coming up this spring. And it's a great time to be able to network with those who are implementing, who are thinking about implementing in the various stages of implementing. So not everybody not all the tribes in this group are, exercising the jurisdiction, or, some are ready to, some are still thinking about it. So if you're thinking about it, it's a great resource. So please contact myself or NCAI, and we can put you in touch with who you need to and get signed up to get the emails. There's a wealth of resources on code development, just everything under the sun, jury pools, all the different things that you need to know to implement this special domestic violence criminal jurisdiction. So I'd like to plug that over and over. And if you know of any tribes that are thinking about implementing or exercising, please tell them to join as well. And okay, let's see. It looks like we have some questions here. Great. Someone said, I have a question regarding the differences between the DV court and DV docket. It seems similar, but I'm still having issues with how they differ. How is the DV court different than the docket if they all have a common thread of domestic violence? Kelly, I'm not sure if you're on mute.
Okay, how about now?
Yep, I can hear you now.
Okay. Well, a DV court is it does share a lot in common with the DV docket, but a DV court is a specialized court, and I suppose I could explain it like this. When the case comes to the clerk, it will have some indicator of domestic violence, whether it came in through a PO or an advocate, or the police report alleges some domestic violence. And so that case would be diverted at that moment over into the DV court, where the specialized judges, law enforcement, this team is going to work with this on victim safety and batterer accountability. They can be civil or criminal, but it is an entirely separate court. They'll keep their records separate. They'll have different personnel. A DV docket, on the other hand, is you're going to use perhaps your same judges and your same law enforcement, but you're going to sort of designate one day to be DV docket day, and you're going to try to hold your DV cases on that particular day for whatever reason you've decided. It could be resources, it could be personnel resources, but on that day, DV docket day, there are going to be special safety precautions taken. There will be a heightened awareness in the court. The advocate will be present. There may be staggered arrival and departure times, but it may not be the same judge every time. You could hope for the judges to be educated in domestic violence. As I said, not all judges are. But this DV docket day is going to lend itself to some enhanced safety features to it. The DV court is going to be this totally different court that has as its purpose victim safety, healthy families, and batterer accountability. And it's got continuity to it. These families are going to be coming in front of the same judge all the time. Hopefully I've cleared that up a little bit.
Thanks, Kelly. That's great. Let's see, I have another question here. Let me open it up here. Okay. Our DV docket was funded under the Justice for Families grant, and the funding ends in September 2016. Would we be eligible to apply for rural sexual assault, domestic violence, dating violence, and stalking assistance programming to enhance our DV docket and to expand services? Steve, I'm not sure if you have that answer.
Yes, you would be. That's the simple question. What you want to do, though, is you want to read carefully through the rural solicitation, but I didn't see anything in there that would indicate that. It's only, the only limitation would be if you had a rural grant in the past that went beyond 2016. Then you might have some limitations.
Thanks, Steve. I don't see any other questions. So unless anybody else has any other comments or points they'd like to make, I'd like to thank Teresa and Kelly and Steve for taking time today to participate on this webinar and provide all the information that you have. It's great. And I'd like to thank all of you for joining the webinar and taking time out of your day to listen. So if you have any questions, please feel free to email me, and I will send out the PowerPoint and other information to you by tomorrow morning at the latest. But I will try to do it shortly. So thank you again, and I hope everybody has a great day.
Thank you.
Thanks, everyone.
Thank you. Bye-bye.
Bye-bye.